Hello friends, today we'll discuss the fundamental rights. Now, the first part of the first fundamental right we'll discuss, that is the state. Before going to the state part, we have to know what is the fundamental right. The part 4 of the Indian Constitution deals with fundamental rights. These fundamental rights are very much fundamental to all the citizens or the person at large. So those rights are justiciable before the court of law. We have seen the constitutional law is a public law. Public law means those types of law which maintain the relationship between the state and its individual. So one side state, other side individual. State is very powerful organ. So that's why this relationship is not between the two individuals or the two persons. The relationship between the hierarchy, state is the higher position and individual in the lower position. That's why the relationship of vertical rights. These rights are known as the vertical rights, up to down. Means those rights are given by the states to its citizen or its person or the minorities, and those persons are entitled to get those rights. So those are fundamental rights and those are enforceable rights. Constitution is guaranteeing these rights are your rights and you can enforce these rights. Where you can enforce? Before the court of law. So those are the justiciable right. Those rights against whom the rights justice may be done, justice may be claimed before the court of law. And we'll see in our constitution in this part, this is a part 4 also, article 32 is given, which where these fundamental rights are justiciable. And when we see the constitutional rights and fundamental rights, those rights are also under 226 of the constitution justiciable before the high courts, also state high courts. Everyone cannot reach before the Supreme Court, or that's why state high courts are there. And if we see the origin of these fundamental rights, which is mentioned in our constitution, Indian constitution, from article 12 to article 35, all of these rights are basically civil and political rights, which are the first generation human rights. When our Indian constitution was framing on that time, the period was the 48 to 49. On those periods, the maker of the Indian constitution, they were very much aware about the UDHR, Universal Declaration of Human Rights. And Universal Declaration of Human Rights, where we can find that there are 30 articles which are divided into 3 major heads. Generally, it is presumed that the 3 generation rights are there, and civil and political rights are the first generation rights. Those are very much needed. Second generation rights are socio-economic cultural rights, and third generation rights are the collective rights or the solidarity rights. So maximum provisions of the civil and political rights, which are the first generation rights, are available in our constitution as the fundamental rights. So that's why fundamental rights are very much fundamental, and we can say it is a basic to know the constitution of India. Now, if it is a vertical, if it is a public law, it deals with the relationship between state and individual. So that's why state is coming here. The definition of state is coming here. So that's why Article 12, the first article of the part 3, means the fundamental right part, is dealing with the state. How means against whom these rights may be claimed, against whom these rights may be enforced, against whom court rights can be justiciable before the court of law. So always in the case of fundamental rights, other side is the state. Now who are states, or which are the coming definition of state, or what are the various types of states, that has been mentioned in Article 12. This article means this part is starting with the Article 12, where the state has been defined in the 4 heads. First, government and the Parliament of India. Means here government means the central government, or you may say the union government, and Parliament of India means central parliament, Parliament of India. Apart from that, in the federal structure, we have the state also. So government of the states and legislature of the state, means parliament of the state or the each state, those are also state. Third, all local authorities. Local authorities are also coming under purview of state. And fourth, other authorities within the territory of India or under the control of the government of India. Means those authorities, other authorities, which are within the territory of India or which are under the control of the government of India. Means it may be outside of India but under the control of the government of India. Now local authorities. Local authorities is generally presumed that those authorities which are at a local level or the self-government level which are functioning as the state. Suppose municipality, a very old case was there in 1950, you can see Rashid Ahmed versus MB Kairana, where it was decided that municipalities are coming under the definition of local authorities, so those are the state. Apart from the district boards, panchayats, cantonments, improvement trust, port trust, or any other local authorities which are functioning as the state mechanism, state machinery, those are also coming under purview of local authorities, and those are the coming within the definition of state. Means writ may be filed against those authorities. Now other authorities. This is very much interesting in Indian Constitution. This other authorities has not been defined. But time to time questions came before the Supreme Court and the High Courts, and categorically Supreme Court will discuss few Supreme Court cases, landmark cases where these other authorities have been deciding time to time. Now, one of the important cases was Electricity Board Rajasthan versus Mohanlal. You can see 1967 case where it was decided. This is a long case. Every case in constitution you find a long case, but basically we discuss the theme of the case. Ultimate, what was the decision relating to the local authority. Here we will find that all authority creates by the constitution or statute on whom powers are conferred by law are local authorities. Means those authorities, sorry, those are other authorities, sorry, other authorities, fourth point, other authorities. Other authorities means those authorities which are created by the constitution or the statutes and on whom powers are conferred by law. The single test is that if any authorities which has been established, which has been created, which has been constituted by the Constitution of India, suppose Constitution of India is telling for the establishment of Public Service Commission or Union Public Service Commission or election commission. So all of these offices or authorities have been created by the Constitution or any other statutes or any of, suppose your Protection of Human Rights Act 1993 is telling for the establishment of National Human Rights Commission or the State Human Rights Commission. So those are being established by statute and on whom powers are conferred by, any powers are given by the law. Here law means statutory law, obviously. So those will be treated as the other authorities, and those are also state. Means any authorities which at least created by the constitution or any statute at least, and where powers are vested by the process of law. Those are treated as the other authorities. It was a decision in a very old case of the Electricity Board versus Mohanlal. Now, if you see, another important case is coming here. Sukhdev Singh versus Bhagavatam case, 1975 case. Here question came that whether public corporations, means public corporation, you know, that big companies, corporations, which are functioning, suppose as the public corporation and doing the business also. They are business motivated. Here governments are doing business also. Business not only done by the individuals only. Governments are also doing the business. So public corporations are being framed or being made immediately after independence. So many public corporations are framed to develop the country, and Question is coming whether those public corporations are coming under the purview of the other authorities, whether their function will be treated as a state function, whether they are state. Now, such type of one important case was the Sukhdev Singh versus Bhagavatam, 1975 case. Here, one thing was decided that public corporation created by statutes and power to make the rules and regulation and control by government indirectly, those are the authorities. If any public corporations and created by statutes, you know, created by statutes means here three issues came into existence. Three organizations were there. ONGC, all the ONGC means oil and natural gas. It was company was created by one act. One of the feature of the public corporation is that in India, those corporations must be created by the process of law. Those corporation has been established by the process of law. So that's why the law is the statute. And ONGC has been established by the Oil and Natural Gas Corporation Act 1959. IFC means Indian Industrial Finance Act was established by Indian Industrial Finance Act. Industrial Finance Corporation was established by Industrial Finance Act 1948. And LIC, we all know LIC, Life Insurance Corporation, was established by the Life Insurance Corporation Act 1956. So all of these are the state, as those have been created by the particular statute or the act of the parliament. Even the state legislation may also be treated as statute. And not only that, another things came into notice that those powers and rules are being framed by them. Those are known as the self-regulatory organizations who can frame the rules and regulation or bylaws. Means who can frame for their functions, for their daily works, for the salaries of their employees, for their any kind of their decorum. Everything should be main rules and regulation they can frame for themselves. So that's why those are the coming under purview of these other authorities. Apart from that, it was also decided that control by government directly. You know, till we have the government has the public accounts committee is there. Apart from that, one particular committee was there, heavy industries and public corporation. So and public corporations, their report, audit reports are being decided, being placed before the parliament also. The parliament has a direct control over the public corporation. Not only that, even indirect control is that, so those will be treated as the other authorities. So public corporation created by statutes and powers to make the rules and regulation and controlled by government indirectly are treated, were treated the criteria for any corporation coming under the purview of other authorities of the state. It was the decision of the Sukhdev Singh versus Bhagavatam case in 1975. And you know, another important case is coming here, that the RD Sethi versus International Airport Authority 1979 case. In this case, what happened? Again, another corporation came into existence, whether that corporation will be treated as a state. Means there is a in administrative law, when you study the administrative law, you will study in detail. This case is very important regarding the biasness also. There was a question of any tender was there, and it was filed a writ petition. Now question came whether writ petition can be filed against the International Airport Authority as a state. The question is coming whether you have to decide the International Airport Authority is state or not. So that's why to replying this question or to answering this question, court has gone through some tests. So again, court has came to this conclusion that corporation acting as state instrumentality or agency of the government, that will be treated. And in this case, International Airport Authority created by International Airport Authority Act 1971 and another authority or the within the meaning of state. So International Airport Authority was decided as a state because it was made by one statute, which was decision on the Bhagavatam case. And another new term came into existence, or a new checklist came into existence, one of the new connotation came into existence, that if corporation is acting as instrumentality or agency of the government. This is a very important thing. Instrumentality and agency means, first thing we have seen that organ, state has organ, and state has the agency also, and state has the instrumentality also. So if this is the state, it is state. If it is a state organ, it is a state. If it is a state agency, it is a state. If it is a state instrumentality, then it is a state. So in this way, it was decided that state instrumentality, any corporation which is working as a state instrumentality or agency of this government, then it is a state also within the meaning of Article 12 of the Indian Constitution. Another corporation issue came into existence, that was a Bharat Petroleum Corporation, and name of the case was Som Prakash Rekhi versus Union of India, AI 1981 case. In this case, issue was that one employee, whether he is entitled to get the pension or not, whether he is the government employee or the public employee. You know, in our IPC, when you study the IPC, you will find the two terms are there in the definition chapter. One is the government servant, another is the public servant. Means section 14 of the IPC and section 21 of the IPC. Now, in this issue, question came, if the organization is the state or other authorities is coming under the purview of the state, then its employee will be the state employee or the government employee, or and gradually if it is coming the state, then automatically it will be the public servant. Now, in this case, deciding this case, Supreme Court again came to the decision the corporation function as the instrumentality of the government is a clear indication of the state. What is the indication? What is the test? If any corporation which is functioning as the instrumentality of the state, then it is coming under the state. Definition of state. Or instrumentality of the government, central government or state government, it will be treated as the state. In this case, what happened? There was a corporation, Bharat Petroleum Corporation, originally registered as a company. It was not created by statute. But what happened? It took took over one company, Burma Cell Company. They used to sell the your oil also, petroleum also, through one of the statute of the parliament, that was a Burma Cell acquisition undertaking in India at 1976. A limb of the government, agency of the government, state, and recognized and clothed. Very finely, Supreme Court has defined. Originally, Bharat Petroleum Corporation was not the statutory corporation. It was registered under the Companies Act. But what happened? During the 76, it acquired the one company. And how it acquired this company? It acquired the company through one legislation, through one act of the parliament, that is a Burma Cell Acquisition of Undertaking in India Act 1976. So, when law, by the process of law, you acquired one company, and that company's all the ownership and its management came under the purview of the government of India. So this company has also become the part of the state, because a limb of the company, this has become a limb of the company, means limb, organ, or body organ, limb of the government. It has become an agency of the state and is recognized and clothed with the rights and duty by the statute. So automatically those statutes are also applicable to that company, and that company is clothed. Supreme Court has very nicely explained that as recognized and clothed with the rights and duties of the statute, so automatically it will become the it is becoming the state instrumentality or government agency. So automatically it is. So this, in this case, it is a company which was registered under Companies Act, but by the process of law, one parliamentary procedure or legal procedure, it acquired another company, and these laws are applicable to this company also. So automatically this company is clothed with the rights and duties of the state, of the statute. So automatically it has become the definition of other authorities, and other authorities mean the state. Means it may lie, fundamental rights may lie against those corporations. Now another famous case is coming here, that is the Ajay Hasia versus Khalid Mujib. This case is very important case. You have to remember this case. All the student of law, constitutional law, have to know this case. This case is another important case, 1981 case. where question came that another issue is coming. The concept of corporation created by statute or not is immaterial. Immaterial spelling is a little bit mistake. You must remember immaterial. But concept of instrumentality or agency of the government is important. This is another important case. Here, the litmus test is that you have seen Sukhdev case, it was told that it must be created by statute. In the Bharat Petroleum case, it was decided that state instrumentality is there. In this case, what happened? The label was the one society. Society, one organization was there, one engineering college was there, which was registered under society. State society, Jammu Kashmir State Society was there. Now question came to the Supreme Court whether this society or any college which has been established under society is coming under the purview of the local other authorities, or whether it will be treated as a state. In this case, Supreme Court is telling that concept of corporation created by statute or not is immaterial. Now creation, it has been created by the statute or any act of the parliament is immaterial. Concept of instrumentality or the agency of the government is important. Means if that corporation of that organization is functioning as the state instrumentality or working as the government agency, that is the most important. And if it is doing so, it will become another purview of state. And in this case, there is a society working as agency and under full control of state government or the central government. So was also a state. So in this way, it was also treated as state. So this is very elaborative case laws. 10 cases are going on every time you find. If in constitution, so many new cases are coming. Every time question is coming whether it is state or not. If it is state, then fundamental right will lie. Then it can lie against the authorities. So that's why so many cases are there. But these cases are up to 80s. These cases are very much important cases. Apart from that, so many cases you have to go through for update your knowledge. Now another issue is coming where the judiciary as a state. If you see, the main thing is that judiciary is missing in the definition of state under Article 12 of the Indian Constitution. Now question is coming, three organs of the state is very important. And those are the three, all the state can function with three organs. That is the executive, legislature and judiciary. If you see the definition of the state under Article 12, it is covering the legislature, means parliament, and other authorities also, executives also, or functionaries, other authorities, or any local authorities to which. But question is lies whether judiciary is treated as a state. Supreme Court is silent in this manner. Time to time, several cases has been decided that judiciary is not coming under the purview of the law, because against the decision of any judicial activity, you have the procedure inside the constitution to go against the decision. So there is no need to file the separate writ petition for the violation of fundamental right. If any person become aggrieved with the decision of the judiciary, they can go for the review. The civil review, criminal review is there, or revision is there, reference provision is there. Apart from that, if you are not satisfied with the deep decision, you can again go for further. Suppose there is a famous case, Rupa Hura versus also Hura, where the curative writ petition came into existence. Against the writ petition also you can find another writ petition. So there is no need of any kind of control. So that's why when judiciary is functioning as a judicial function, judiciary has two functions. Judiciary as a high court, he has an administrative function also. Supreme Court has the administrative function also. Their own appointment, their own judges appointment, their salary, their administrative decision. Those may be the subject of the when they are functioning as a non-judicial function, they may be subject to the writ petition or judicial. But against the judicial function, there is no scope of the violation of fundamental rights. This is an existing rule. Till date, those cases are there. But apart from that, So many avenues are there to explore this area. Hope you have got the idea about the concept of the state under the fundamental rights of the Indian Constitution.